Okay, so you guys know we did a documentary called Obsessed, Unraveling Jodi Arias last year in November. We looked into her psychology, and part of that documentary was revealing the fact that she is running a blog from prison. Now, as people know, Jodi Arias was convicted and sentenced to life in prison without the possibility of parole for killing her ex-boyfriend, Travis Alexander, back in 2008 in his Mesa, Arizona home. She stabbed him in the shower 27 times. She shot him, then she lied about it, tried to get away with it, and it ended up becoming basically the most salacious trial of the turn of the century, and honestly, one of the most salacious trials that has ever happened in U.S. history. So she's been in prison. She is somebody who likes attention. She wasn't able to talk to me due to her attorneys in her appeal. But she did email me during the production of the documentary, and she runs this blog. You're seeing it on your screen. It's called Just Jodi. And in it, she talks about her daily life and her thoughts and her feelings and her opinions. And it's really the same that she did when she was writing in her journal before and after the murder of Travis Alexander. She has a very specific tone. It's fairly snarky, yada, yada, yada. The thing is, typically, she does not address the case at all in her blog posts. And that was something that I knew we were going to struggle with the documentary, because she just wouldn't talk about it anymore. It was more about, hey, do you want to know what I'm baking? Or do you want to know about my pet bird named April? Or do you want to know what I think about smoking or AI? It was like things like that. So I knew her attorneys in this appeal, her defense team now, did not want her to say anything to me, anything to media, and certainly not anything about the case if they're trying to get an appeal for the trial that played out in front of the world. But Jodi Arias is Jodi Arias, and she kind of does what she wants. So I subscribed to her blog as a journalist who follows her case and follows her. And in my inbox, it said, Just Jodi, new blog post with the title, Hello 2026. Clicked it, didn't know exactly what it was going to say. I'm also still hoping she'll address some questions I had sent to her a while ago as well. So I never quite know what we're going to see. And in this post, she addresses several different topics, but a lot of it revolves around her case itself, the trial, potential and alleged lost evidence, a habeas corpus case. I mean, we're talking the most that I have ever seen Jodi Arias discuss the case at all in writing for many years. So I want to take you through parts of that blog post before we get some analytics on it from an attorney who knows the case very well. So let me just read you some of what she said about the case itself in this new blog post, and then we'll go through what that all means and does she have a chance at appeal. So here's something that she said at kind of the top of it. Important exculpatory evidence in my case has been lost or destroyed. Where's my proof? I'm working on that. My lawyers yawn when I explain this. Detective Flores or some other henchman acting at Juan's behest likely destroyed or disappeared this exculpatory evidence. Maybe one of them will gain a conscience and admit to their tampering. Okay. Interesting. She's claiming there was evidence that they did not want to be part of this. She's referring to Mesa PD detective, retired detective Steve Flores, who headed up this investigation, and Juan Martinez, the fiery prosecutor who was on the case. So you've got her claiming the evidence portion of this. Then she talks about having a big fallout with one of the attorneys who's on her case and how she's lost this relationship and she felt betrayed and she's mourning this loss. And she says, very snarkily, I might add, in case you're guessing who I'm referring to, I've confided in, let me count, over 18 lawyers. So you're probably wrong. I'm sorry to be stingy with the details here, but I must. There is a theme in my life of being manipulated, exploited, and deceived by attorneys. I can definitely tell you guys that over 18 attorneys is definitely not normal under any circumstance. I know she went through many attorneys just to get to the trial portion, and that was back between 2008 and 2013. So now, obviously being in 2026, that's given her many years to go through other people. I think it just depends on who she actually wants to do what she wants to do, and maybe not what attorneys typically do. Okay, the last thing she said, the last way that she ended this, was when she's talking about post-conviction relief. That stands PCR is how they reference it. And the thing is, when you go through appeals like this in Arizona and many states, you go through the appeal process after a conviction, typically over and over again, depending on if you lose that appeal. But once you run out of appeals, then you can look towards something else. And for her, it's a habeas case, which basically means she's going to claim that her constitutional rights were violated during the trial. There might be something to that in terms of the fact that both attorneys were disbarred in this case. That's very unusual. But it seems that she is just going to be looking ahead now and is trying to find new counsel to represent her. So let me read what she said at the very end of her blog post. For 5 years, PCR has been a watched pot that I'm beginning to realize will never boil. I have been naive to approach it the way I approached my case during the pretrial phase, which has been to let attorneys who didn't care as much as I do, through no fault of their own, nobody can care as much as I do, take the wheel while I buckle up and cruise through it, hoping to reach destination freedom. On that note, I'm going to reach out to those new lawyers now. Happy freaking New Year. You gotta love that Jodi dig there at the end. Happy freaking New Year. So it looks like she's looking for new counsel. Now, I reached out to her attorneys, her defense team, asking if they have anything to say to this. I mean, their clients basically going on there and just saying, hey, I have an issue with all these people and I'm gonna look for new counsel. And wanted to know not only their thoughts, but are they still Jodi's defense team right now in this appeal? And the only thing I got back was no comment. So I don't know exactly where it all stands, but clearly there's some things to be sorted out. Now, Jodi is Jodi. We know that she's narcissistic. We know that she has some psychological disorders that have been diagnosed by psychologists. But does she have any chance here? Does she have a possibility that under some sort of protocol issue or misconduct during the trial phase, could she get out on that? And I wanted to ask an attorney about what this all meant. So I consulted attorney Tom Ryan. He's based in Chandler, Arizona. I've worked with him for a lot of time and a lot of years now. He was not directly involved in this case during the trial phase or anything like that. However, after the second trial, she was up for death penalty. A jury could not come to a conclusion on that, so it was a mistrial. Another jury took it up. They also couldn't come to a unanimous decision, so then it was an automatic life in prison. In that second time, there was one juror who held out on the death penalty. The rest of that jury believed she should be put to death. Tom Ryan ended up representing that sole juror after the trial when she was getting death threats and all sorts of things, being the one person that changed the fact that that was a mistrial. So he was involved in that way, but he was not involved in the trial itself. So when we're talking about what this looks like from what she's saying and claiming could happen to what actually could happen in court, he's looking at this from an objective third-party position. But let's just find out. I want to know what happens. And so earlier this week, I sat down with Tom Ryan from here in our studio, and I want to play that interview now. What could happen with what Jodi's claiming? Here's that interview. Obviously, we all know the Jodi Arias story, and there's a lot to it. Typically in her blog posts, she doesn't talk about the case. It's all about her life in Perryville, and I have a pet bird, and I cook, and I don't like my roommate, smoking, things like that. But this is really the first time that she's kind of addressed where her case stands and her feelings on evidence and things like that. One of the first things she addressed is claiming that evidence was destroyed by the lead detective, Steve Flores, and the prosecutor, Juan Martinez. What did you make of her claims on that part?
Well, it's hard to judge for a variety of reasons. First off, this case has a long history, and I went back and looked both at the Superior Court and the Appellate Court level. Recently, there was some evidence or motions that were filed under seal, which the court granted, so that precludes my review of everything. So let's go back and answer the general question first. Can the state destroy evidence that is likely to be exculpatory, meaning show that a defendant is innocent? If that happened, that could be a basis for overturning a conviction. There is no evidence of that yet, nor do I necessarily expect there to be it. The second question is, if evidence has been lost or destroyed, what is the relevance of it? Not everything that's been lost or destroyed will necessarily result in a reason or a basis for overturning the conviction. The court looks at whether or not it was prejudicial as well. So it matters how material was it, how relevant was it, and how significant was to her defense. At this point, we don't know. We just have her saying they destroyed exculpatory evidence for me.
Now, exculpatory evidence, a lot of people are going to look at this and say, wait a minute, she got on the stand and said, I killed him, I did this. How does that work?
Great question. How does exculpatory evidence work when somebody has admitted they've done something wrong, committed a criminal act? Keep in mind there are varying degrees of criminal intent that the court and jury must look at when a defendant is being tried. So the evidence may have tended to show she acted with a lesser level of intent than the jury found her guilty of. So it could be relevant to a question of, hey, I should have been found only guilty of second degree murder or manslaughter, something like that. Again, I don't know the evidence that she claims is missing, but on a kind of a ethereal general basis, that's how exculpatory evidence would work, where somebody's actually admitted, I did hit him, I did shoot him, or whatever.
And in this case, I assume then she would try to not only fight for that, but it would, her time served would maybe count then towards a lesser conviction.
Could it end up shortening her prison stay? It is possible. Doing petitions for post-conviction relief are very difficult. You have to show that, for example, the judge was just acting arbitrarily, irrationally, capriciously. You have to show that you had inadequate assistance of counsel such that it materially affected the ability of the jury to fairly decide your guilt or innocence. The evidence or the issue here is whether or not evidence was destroyed. Again, that goes to how material was it? Was it likely to be prejudicial? So, assuming that there is something out there that she thinks is really, vital and material and relevant, it is possible that she would be retried. I don't think she would just be resentenced. She would be retried. It's possible they could strike, if a court found that evidence was destroyed, a court could retry her, but then the state would have the right to sit with her and talk to her about a lesser included offense and do a plea agreement.
Got it. Okay. So there, it almost seems like there's two parts in her blog post. One is this evidence that was allegedly destroyed that she's claiming that would prove her innocence. And then there's this other side where she's unhappy with her counsel. She's gone through 18 attorneys that she said in this post-conviction relief, this PCR. And now she's eyeing a habeas case past PCR. That deals more with her constitutional rights within a trial, correct?
Yes.
Can you explain a little bit what that would be for her? I mean, is she going to be eyeing the prosecution, the defense, or other happenings that is outside of the actual evidence in the case, but more so about how she was treated or handled?
That's exactly what she's trying to do, is to say that she's trying to allege there was state misconduct that materially affected her ability to prove her innocence of all charges or some lesser included charge or the greater charge. Keep in mind, they were trying to get the death penalty here and were unable to, after two different juries, determine that there was insufficient evidence to invoke the capital punishment. But you bring up another issue that I think is important, which is she claims to have had at some point or another access to 18 different attorneys who were trying to help her with her defense and post conviction relief. At some point in time, you have to look at what's happened here and recognize maybe it's not the attorneys, maybe it's the client herself who's not accepting reality. That's a possibility.
Well, yeah, and that is a high amount of attorneys, is it not, for that?
Typically when somebody loses a criminal case, they're very unhappy with their lawyer. That's not an unusual thing.
Does she have a point? Does she have a possibility here, given that both of the lead attorneys were disbarred and there was prosecutorial misconduct in at least some form or fashion, maybe not how Jodi's explaining it, but that did become a part of this case. Do you think she's kind of banking on all of that that's happened to try to then use it in her favor?
Yes, that's exactly what she's trying to do here. Is I've had two attorneys that have been disbarred. I've had there's some question about whether or not evidence was properly turned over. The main prosecutor was being on his way to being disbarred, but then resigned before he could be disbarred. So yeah, there are some questions here. this was a messy case from start to finish. Every aspect of it was horribly messy. But it did result in a conviction. And if you look at the work of the two juries, I believe they did so in good faith and in fair dealing towards Jodi and the state of Arizona. Um, Having acknowledged that, yeah, it's not helpful to have attorneys disbarred. It's not helpful to find out that evidence was destroyed, lost, or intentionally not turned over. Those are all bad things. If she can prove a combination of all those things and show that there was so much mess in the way the trial was handled that it was overwhelming, it is possible, but I'm going to say not likely to get this conviction overturned.
That's what I was going to ask you. If you could, and I know it's hard to put a specific number, but a 0 to 100% chance, give or take, what do you think she'd have?
Well, it really depends on what is the evidence. What is the evidence that she claims was lost or destroyed intentionally? And that's the next question. If you lose it, but it wasn't intentional, that's very different than you lose it because you didn't want somebody to see it. So intentionality matters. And then the next part of it is materiality. How material was the evidence that she claims was lost material to her defense? And is it relevant? I mean, if the teddy bear was lost, but the teddy bear had no bearing on anything that happened in the case, that then it's not relevant.
Right.
Materiality means what you lost a fingernail versus you threw out all the DNA evidence. One's not material, the other is. And then again, what is the basis for the conduct? If I just lost something, that's not my intent to destroy your ability to represent yourself and defend yourself. But if I do it because I think it's going to ruin my prosecution of this case, that matters. So intentionality, materiality, relevancy, all of those things will come into play. And until we know what evidence she claims is lost and the circumstances behind that, if in fact such evidence is lost or destroyed, it's hard to judge. But I will say, if you ask for my overall gestalt, the likelihood of her seeing an overturned conviction here is somewhere between slim and none.
Fair. I mean, that's fair. And do you put that same kind of likelihood or probability on the habeas part of this as well?
Yeah. Again, it goes back, yes, but it still goes to depend on does she really know what she's talking about? Was material evidence lost? Was it intentionally destroyed? And is it relevant to her case? If those three things can be met, well, then her chances of success on a habeas petition it will increase. But absent a nice combination of those three, more likely than not, she'll continue writing her blog post from Perryville.
So she couldn't I mean, if all those things aren't true, she couldn't just write on the fact that the attorneys were disbarred and there was misconduct there, you don't think?
No, because the inadequate assistance of counsel was addressed at the time of the trial and on appeal as well. It is unlikely that any state or federal court will overturn that. The bar for inadequate assistance of counsel or ineffective assistance of counsel is very, very low in the United States.
Interesting. And just last question for you. Her snarky tone then and now seems to be the exact same. The way that she writes the blog post is the same way that she wrote in her journal before and after the crime. It's the same kind of tone she seemed to take in the trial when she would address attorneys and other people. How does that weigh in for her now, do you think, both legally and just from the public standpoint?
Well, I think it's more of a public issue than a court issue. And here's why I say that. Judges are required to put aside personality likes and dislikes when they are ruling on matters when a client or parties are in front of them. Not clients, but parties are in front of them. But I think it's the public thing is more important here in that um, Jodi has not been able to address her own misconduct in all of this. She's the victim in this story, and she cannot get over that. And until she understands that, there aren't going to be too many people who are willing to help her out. The idea that she's had 18 lawyers and she knows more about the law in criminal defense than those 18 lawyers tells me all I need to know about the narcissism that she's experiencing.
Yeah, that's completely fair. I appreciate all of this because it can be confusing when you're trying to understand PCR versus habeas versus the trial itself and all of that. So just having you be able to kind of break it down and explain it in layman's terms to those of us who are not attorneys, I super appreciate it.